out now. Why would he take off? Why would he take off?
My mom wants to talk to you.
What's the difference between staying calm with visible hands, demanding a lawyer, and refusing to unlock your phone? Each protects a different constitutional right, and knowing which phrase to say when could mean the difference between walking away free or facing serious challenges. But there's one crucial mistake most kids make that even parents don't know about. Stay calm, hands visible, voice low. The very first thing your child needs to understand about any police encounter is this. Their physical demeanor can literally determine whether the situation escalates or de-escalates. Teach your kids to say clearly and calmly, "I'm staying calm and keeping my hands where you can see them." This simple phrase, combined with visible hands and a controlled voice, can be the difference between a peaceful interaction and a violent confrontation. The legal foundation for this advice comes from the landmark case Terry versus Ohio, 1968, which established the concept of reasonable suspicion for police stops and frisks. This Supreme Court decision essentially gave law enforcement officers the authority to conduct a pat-down search if they have a reasonable suspicion that someone might be armed and dangerous. If an officer believes there's a threat, they can legally pat down your child for weapons. Why does this matter? Because courts consistently throw out evidence when police overreact to situations, but they also uphold police actions when suspects make sudden, threatening movements. By teaching your child to keep their hands visible and their voice low, you're giving them a powerful tool to reduce escalation. The Terry vs. Ohio ruling remains one of the most frequently cited cases in police encounter situations, and understanding its implications could quite literally save your child's life. While staying calm controls the physical aspects of the encounter, the next tip addresses what your child should say to immediately shift the legal dynamics in their favor. Ask for parent-guardian immediately. The moment any law enforcement officer approaches your child with questions, your child needs to know these exact words. "I'm a minor. I want my parent or guardian here now." This isn't a request. It's an invocation of a fundamental constitutional right established specifically to protect children from being taken advantage of by the justice system. The legal precedent here comes from in Regault, 1967, a watershed Supreme Court case that fundamentally transformed juvenile justice in America. The Galt case involved a 15-year-old boy who was sentenced to nearly 6 years in a juvenile detention facility for making an allegedly obscene phone call, and he was never given a lawyer, never informed of his right to remain silent, and his parents weren't even notified of the hearing until after he'd already been taken into custody. The in re Galt decision established that juveniles have heightened due process protections, and most states now require parental presence for any custodial questioning of minors. But here's the critical part. This protection only works if your child actually invokes it. If your child starts answering questions before demanding that you be present, they may inadvertently waive this protection. Practice this phrase until it becomes automatic. "I'm a minor. I want my parent or guardian here now." While asking for a parent provides immediate protective presence. The next fundamental right your child must invoke works hand in hand with parental notification to create a complete shield against self-incrimination. Invoke right to silence, Miranda. Once your child has asked for you to be present, the next critical phrase they need to know is, "I'm choosing to remain silent." These 6 words carry the full weight of the United States Constitution behind them, specifically the Fifth Amendment's protection against self-incrimination. Miranda versus Arizona, 1966, is the case that gave us the Miranda warnings we've all heard countless times. You have the right to remain silent. Anything you say can and will be used against you in a court of law. The Supreme Court's ruling in Miranda established that silence cannot be used against you in court. Your child's refusal to speak cannot be presented as evidence of guilt. However, even before Miranda warnings are given, statements can still potentially be suppressed in court if they weren't given voluntarily. This is why it's crucial for your child to invoke their right to silence immediately. The phrase, "I'm choosing to remain silent," makes it crystal clear that your child is exercising their constitutional right, not just refusing to cooperate. In the heat of the moment, scared and confused, kids say things that can be misinterpreted, taken out of context, or used to build a case against them, even when they've done nothing wrong. The right to remain silent exists specifically to prevent this from happening. Silence protects your child from saying anything incriminating, but there's another constitutional right that goes even further by ensuring professional legal protection is present before any questioning occurs. Demand a lawyer. Right alongside the right to remain silent comes another fundamental constitutional protection. "I want a lawyer right now." These 6 words trigger what lawyers call an automatic cutoff of all questioning. Once your child says this legally, all interrogation must cease immediately. For juveniles specifically, there's Fair versus Michael C., 1979, which involved a 16-year-old boy who asked to speak with his probation officer instead of explicitly requesting a lawyer. The Supreme Court ruled that asking for a probation officer wasn't the same as asking for a lawyer. answer. But the Fair versus Michael C. decision also firmly established that minors absolutely can invoke their Miranda rights, and when they specifically ask for a lawyer, all questioning must stop. Your child must be clear and unambiguous. "I think I might want a lawyer" isn't good enough. The phrase needs to be direct and definitive. "I want a lawyer right now." Explain to them that asking for a lawyer isn't an admission of guilt. It's a smart exercise of their constitutional rights, and it's what innocent people do to protect themselves. While demanding a lawyer protects your child during questioning, the next constitutional right prevents police from gathering physical evidence from your child's belongings without proper legal justification. Refuse all searches. Here's a scenario that plays out thousands of times every day. A police officer asks a young person, "Do you mind if I search your backpack?" Many kids, wanting to appear cooperative, simply agree. This is a critical mistake. The phrase they need to know is, "I do not consent to any search of me, my bag, or my phone." The landmark case Katz v. United States, 1967, established the principle of a reasonable expectation of privacy, and the Supreme Court's ruling in Katz made it clear that searches generally require either a warrant or a specific legal exception. But here's the thing, consent is one of those exceptions. If your child agrees to a search, they've voluntarily waived their Fourth Amendment protection. The Katz versus United States precedent means that by refusing consent, your child forces police to justify their search through other means. They need probable cause or a warrant. If police conduct a search without proper legal justification, any evidence they find can be suppressed. But if your child consents to the search, that suppression option disappears. Teach your children that refusing consent isn't suspicious. It's constitutional. Just as refusing searches protects against physical intrusions, your child must also understand that seemingly innocent verbal responses can be just as dangerous as consenting to a search. Don't answer even harmless questions. One of the most dangerous misconceptions young people have is that some questions are harmless and therefore safe to answer. This is exactly what law enforcement is counting on, and it's why your child needs to know this phrase. "I'm not answering any questions without a lawyer." The legal principle here comes from Berkemer v. McCarty, 1984, which ruled that roadside questioning can very quickly transition from a casual encounter to a custodial interrogation. But it's not always clear where that line is, and by the time your child realizes they've crossed it, they may have already said something incriminating. Consider this. An officer asks, "What's in your backpack?" Your child says, "Just my school stuff and my friend's jacket." But what if that jacket has something problematic in the pockets that your child didn't know about? That seemingly harmless question just created probable cause for a search. Questions that seem routine can quickly become the basis for searches, arrests, or charges. The safest approach is simple. Don't answer any questions, even the ones that seem harmless. While refusing to answer questions prevents your child from inadvertently providing damaging information. There's another powerful question they can ask that clarifies whether they're even required to stay in the first place. Ask if you're free to leave. Not every interaction with law enforcement is an arrest or even a detention. Sometimes, police are simply fishing for information, and your child has every right to walk away. The phrase your child needs to know is, "Officer, am I being detained or am I free to go?" This question is based on Florida versus Royer, 1983, which ruled that if a person isn't being detained, they can simply walk away. This question forces the officer to make a decision. If the officer says, "You're free to go," your child can politely leave. If the officer says, "You're being detained," then that detention must be based on reasonable suspicion of criminal activity. Either way, the question clarifies the situation and gives your child information about their legal status. Many young people assume that when a police officer starts asking questions, they're obligated to stay and answer. The Florida versus Royer precedent makes it clear that this isn't true. Knowing when you can leave is crucial, but equally important is ensuring your child can actually contact help if they can't leave, which is why the next tip focuses on something technology has made us forget. Memorize one emergency number. We've become so dependent on smartphones that most of us couldn't tell you our spouse's phone number without looking it up. But here's a sobering reality. When your child is stopped by police, their phone can be seized. This is why you need to make sure your child has at least one emergency number memorized. The legal foundation comes from Gideon versus Wainwright, 1963, which established the right to counsel. The Gideon ruling made it clear that the right to an attorney is fundamental and extends to juveniles. But having a right to an attorney doesn't help if your child can't actually contact one. Make your child memorize at least one phone number, yours, a trusted relative's, or a family attorney's. Quiz them regularly. Also, research the number for your local juvenile public defender's office and have your child memorize that too. While memorizing numbers ensures your child can call for help, the next tip addresses what they absolutely must never do, even when every instinct might be screaming at them to fight back. Never resist physically. Use words. This is perhaps the most critical tip for your child's physical safety. No matter what happens, your child must never physically resist. The phrase they need to know is, "I'm not resisting, I'm invoking my rights." The legal standard comes from Graham versus Connor, 1989, which established that force must be objectively reasonable. But what seems unreasonable to your child in the moment might be deemed reasonable by a court later. Moreover, physical resistance, even if the original stop was illegal, creates new charges such as resisting arrest. The Graham versus Connor standard means officers are given significant leeway in responding to perceived threats. If your child pulls away or pushes back, these actions can be interpreted as resistance, justifying increased force. And even if the police stop was illegal from the start, resisting that illegal detention is still a crime. In most jurisdictions, your child needs to understand the time to fight police misconduct is in court, not on the street. Verbal assertion of rights is protected. Physical resistance can be fatal. While your child should never physically resist, they can use modern technology to create an objective record of the encounter, but only if they understand the legal rules around recording police. Record, if legal in your state. We all carry high-quality video cameras in our pockets. This technology can be your child's best defense against false claims, but only if they know how to use it legally. The phrase your child should say is, "I'm recording this interaction for my safety." The legal landscape was clarified by ACLU versus Alvarez, 2011, which ruled that the First Amendment protects the right to record police officers performing their public duties. However, recording laws vary by state. 38 states have one-party consent laws, meaning as long as your child consents to the recording, it's legal, but 12 states require two-party consent. Check the Reporters Committee's Guide to Recording Laws. Video evidence protects against false claims. The ACLU versus Alvarez precedent established that this documentation is constitutionally protected. Make sure your child knows how to protect the recording by having it automatically upload to a cloud service. While recording creates a visual record of what happened, the next tip addresses another way police might try to create a written record, one that could work against your child. Don't sign anything. Imagine this. Your child is at a police station, and an officer slides a piece of paper across the table. "Just sign here," the officer says. Your child needs to remember these words. "I won't sign until my parent and lawyer review it." The legal precedent comes from Haley versus Ohio, 1948, which recognized that young people are especially vulnerable to pressure and manipulation. A signature can be many things: a waiver of Miranda rights, a statement admitting to facts, a consent form, or a confession. In the stress of a police encounter, your child might not fully comprehend what they're signing. This is why the blanket rule needs to be, never sign anything without parental and legal review. Teach your child that refusing to sign isn't obstruction. It's a smart exercise of their rights. Nothing gets signed without you and a lawyer looking at it first. While refusing to sign documents protects your child in formal police settings, the rules change significantly when the encounter happens on school property, a distinction many don't realize exists. No school rules. Different. Constitutional rights that protect your child on the street operate differently on school property. Schools have broader authority to search and question students. The phrase your child needs for school situations is, "I want my parent before speaking to police or principal." The legal landscape was defined by New Jersey v. TLO in 1985, which ruled that school officials need only reasonable suspicion rather than probable cause to conduct searches, a significantly lower standard. But while New Jersey v. TLO lowered the standard for school searches, it didn't eliminate students' rights entirely, particularly regarding questioning. Many states still require parental notification when police question students at school. Schools often try to bypass these protections. A school resource officer might pull your child aside without calling you first, framing it as just a conversation. Your child needs to understand that being on school property doesn't mean they lose their constitutional rights. Just as schools present unique challenges to constitutional protections, another modern technology, the smartphone, presents its own special privacy concerns. Refuse to unlock phone. Your child's smartphone contains more personal information than their home, car, and wallet combined. If police ask your child to unlock their phone, they need to know exactly what to say. "I'm not unlocking my phone without a warrant." The legal protection comes from Riley v. California, 2014, which ruled unanimously that cell phones contain vast quantities of personal information and require warrant protection. Chief Justice John Roberts noted that modern cell phones are essentially comprehensive records of people's lives. The Riley v. California decision established clear Fourth Amendment protections for cell phone contents. But here's where it gets tricky. Biometric unlocks. While the Fifth Amendment protects against compelled testimony, meaning police generally can't force you to give them your passcode, courts are split on whether biometric unlocks fall under the same protection. Consider having your child use a passcode instead of biometric unlocks. Most modern smartphones have emergency lockdown features that quickly disable biometric unlocks. The key message: phones are private and your child should never voluntarily give up that protection. Protecting digital privacy is important, but so is creating accountability through basic identification, which the next tip ensures your child can establish from the beginning of any encounter. Ask for badge number and name. Accountability is one of the most powerful tools your child has in a police encounter. The request is simple. Can I have your name and badge number, please? The legal foundation comes from federal and state identification statutes that generally require officers to provide their names and badge numbers when requested. Additionally, over 30 states now mandate body cameras for police officers. Why is this important? First, it creates accountability in the moment. When an officer knows your child has their identification, they're more likely to follow proper procedures. Second, it creates a paper trail for complaints or legal action later. Third, it signals that your child is aware of their rights and is paying attention. Teach your child to make this request early in any police encounter, politely but firmly. They should record the information immediately or memorize it and write it down as soon as possible. While getting identification creates accountability, there's another verbal pitfall your child must avoid, one where both lying and telling the truth can be dangerous, but silence remains safe. Don't lie, but don't help. Many young people think that since they're innocent, they should just tell the truth, or they panic and think lying will help. Both approaches are dangerous. Your child needs to understand, I'm remaining silent. The legal backing comes from Brogan v. United States, 1998, which established that lying to federal agents is itself a prosecutable crime, even if the lie is about something inconsequential. But silence is not a crime. Your child cannot be prosecuted for choosing not to speak. If an officer asks, "Were you at the park last night?" and your child says no when they actually were there, that's a false statement that could be prosecuted. But if your child says, "I'm remaining silent," that's a constitutionally protected choice. The Brogan versus United States precedent makes it clear that lying is actively harmful and potentially criminal. But silence is golden. When in doubt, the answer should always be, "I'm remaining silent." While silence protects your child from verbal mistakes, if they find themselves physically restrained, there's a specific question they need to ask that could determine the legality of their entire detention. If handcuffed, ask why. If your child ever finds themselves in handcuffs, they need to remember to ask a crucial question. What is the probable cause for this detention? The legal standard comes from Dunaway v. New York, 1979, which established that police need probable cause, not just reasonable suspicion, to arrest someone. Probable cause means there must be sufficient facts and circumstances that would lead a reasonable person to believe a crime has been committed and that the person being arrested committed it. The Dunaway v. New York ruling makes it clear that handcuffing someone requires this probable cause, and if it doesn't exist, the arrest is illegal. Asking the question forces the officer to articulate their justification. If they can't provide a coherent explanation, that's a red flag that the arrest might be unlawful. This question creates a record of the officer's stated justification and provides crucial information that a lawyer can use later. While knowing why you're being detained is crucial, juveniles have access to an additional protection that many families don't even know exists. Specially trained officers who understand the unique vulnerabilities of young suspects. Request a juvenile officer. Many states require that juveniles be questioned by specially trained juvenile officers rather than regular law enforcement. Your child's phrase for this situation is, "I'm a minor. Can a juvenile detective be present?" The legal framework varies by state, but many jurisdictions have specific statutes that mandate specialized handling of juvenile suspects. For example, California Welfare and Institutions Code, 625, require specific procedures for the detention and questioning of minors. The reason is straightforward. Specialized training equals fewer coerced statements. Officers trained to work with juveniles understand developmental psychology and are less likely to use manipulative techniques. Not all jurisdictions have dedicated juvenile officers, so your child needs to combine this request with all their other rights assertions. Making this request isn't about being difficult. It's about ensuring they're treated according to the special protections that the law provides for juveniles. Requesting a juvenile officer protects your child during questioning at a police station, but there's another way police might try to get your child to that station, one that seems voluntary but carries serious legal implications. Never consent to ride in patrol car. Picture this. An officer says, "We just need to ask you some questions down at the station. We can give you a ride in the patrol car." The phrase your child needs to say is, "I don't consent to going anywhere." The legal principle comes from Hayes versus Florida, 1985, which established that police cannot transport someone to the police station without probable cause. The Supreme Court ruled that such transport without adequate legal justification constitutes an illegal seizure. But here's the catch. If your child consents to the transport, it's no longer an illegal seizure. It becomes a voluntary action. Voluntary ride-alongs convert what would be an illegal detention into a consensual encounter, eliminating one of your child's most important protections. If police want to question your child at the station, they can either arrest them, which requires probable cause, or make arrangements for your child to come with you and a lawyer present. The answer to any request for transport must always be, "I don't consent to going anywhere." While federal constitutional protections apply everywhere, individual states often provide even stronger protections for juveniles, protections your child must know about and actively invoke. Know your state's juvenile Miranda rules. The Miranda rules that apply to adults aren't quite the same as those for juveniles, and these rules vary significantly from state to state. Some states provide additional protections for minors beyond what the federal constitution requires. For example, some states like Colorado and Illinois require both parental presence and the presence of an attorney before a juvenile can validly waive their Miranda rights. These state-specific rules recognize that children are especially vulnerable to pressure. The National Council of Juvenile and Family Court Judges maintains resources on juvenile Miranda variations by state, and these variations can be substantial. Non-compliant waivers, meaning waivers that don't follow your state's specific requirements, can be suppressed, but this protection only works if your child understands and invokes their rights. Look up your state's juvenile Miranda requirements and teach those specific requirements to your child. All 19 previous tips focus on what your child should do during the encounter itself, but the final and perhaps most overlooked tip addresses what happens after, when the immediate danger has passed, but the legal implications are just beginning. Aftermath. Write it down. The encounter is over. Your child is safe. But this is actually one of the most critical moments because what your child does immediately afterward can have huge implications for any legal proceedings that might follow. The action your child needs to take is simple. Write everything down immediately. The legal principle comes from Brady v. Maryland, 1963, which established that prosecutors must disclose evidence favorable to the defendant. But Brady also highlights the importance of evidence preservation. If evidence isn't documented, it effectively doesn't exist in the legal system. As soon as your child is safe, they should text you every detail they can remember. What time did the encounter happen? Exactly where did it occur? What were the officers' names and badge numbers? What exactly was said? Were there any witnesses? Did the officers search anything? Were there body cameras visible? These contemporaneous notes are gold in court. They're considered more reliable than testimony given months later. Your child's written account from immediately after the incident can be powerful evidence, especially if it contradicts the police report or supports claims of misconduct. Teach your child a simple system. As soon as they're safe, they should open their phone and send you a text message with every detail they can remember. The act of texting forces them to organize their thoughts and creates a timestamp. The key is creating a record that is both detailed and timestamped as close to the event as possible. Thanks for watching. Check out other cards on the screen.